Hello YouTube, I'm Vince White. I'm an employment attorney. On this channel, we answer publicly posted questions from YouTube users, getting folks the answer they need from an employment attorney. We have a question here from YouTube user, not today, Satan. Great username. Not today, Satan F6P. Who asks us, "Hi Vince, I've been watching your videos for the past 6 months as I deal with my own employment shit show. I'm sorry to hear that, but thanks for the views. You often pose the exact question I'm wondering about. That makes me feel great. Here are two I haven't seen yet. 1. What is the difference between attorney's fees and contingency fees? Are they the same thing? When an employer agrees to pay a plaintiff's attorney fee, is this above and beyond the contingency fees? If they don't cover these, is this something the plaintiff should expect to pay in addition to the contingency fee? 2. As someone who is still employed by the institution I am suing, I am, shocker, experiencing retaliation, loss of responsibility and prestige, and isolation at work. At what point does the initial value of a case go up, and how is this assessed?" Okay. Okay, attorney's fees. The phrase attorney fee is thrown around in a lot of different contexts. So let's just kind of identify real quick off the top of my head a couple of those contexts. The attorney fee can just be the contingent fee, right? If you're just settling a case and you're doing a settlement agreement, attorneys may refer to the attorney fee as the contingent percentage, right? The percentage of the full settlement that goes to the attorney as a result of their contingent percentage, which whatever their percentage is with you, what they get on the case, right? If they're getting a third or 35% or 40% or whatever they get for you, so, you know, they're getting 35 cents on the dollar, 40 cents on the dollar, that will sometimes be referred to as the attorney fee. Now, there are also other contexts where you can refer to attorney's fees. If you go to trial and win in many state jurisdictions, under many sets of state laws, and certainly under the federal laws as well, most of the federal laws in this field, some of the federal laws in this field, you can, because you won at trial, make an attorney fee application. Now, that attorney fee is to be paid by the other side as ordered by the court. And there's going to be a whole skirmish about how much that attorney fee should be and how many hours the firm spent and how well they track their hours and what their hourly rate should be. And you're going to get affidavits from other firms saying, yeah, those guys are the best. They should charge $30 million an hour. And everybody's fighting about what the attorney fee provision should be. And then ultimately the judge will make a decision as to what the attorney fee is. Now, how that attorney fee is handled varies from firm to firm and also to some extent from jurisdiction to jurisdiction, because there's some rules in some jurisdictions that make things a little bit different. What I can tell you is this. My firm, if we get an attorney fee award at a trial victory, let's say hypothetically, we'll do super easy math. Let's say the verdict was for $1 million. Just keep it super simple. And let's say it's 40% contingency, so the firm is going to get $400,000. And then the judge comes in and awards our firm $200,000 in attorney's fees. Well, we would go to the client and say, hey, the judge just awarded us $200,000 in attorney's fees as paid by the other side, separate and above from your verdict of $1 million. So the other side is now paying $1,200,000, but the last $200,000 is attorney fees directly paid to our firm. And so we're going to reduce our contingent percentage by $200,000 because that's the attorney fee granted to us by this judge. And so we're going to take a mere 20% of your $1 million, so we'll be taking $200,000. That is not how every firm does it. And you need to look at your retainer agreement to see how attorney's fees are being handled in your retainer agreement. If they're not at all, it can get a bit dicey later. And there's actually a lot of firms out there in the country that I've noticed that don't deal with this in their retainer agreement. And when they don't deal with it, heaven forbid, it comes to pass that they get an attorney's fees award for you. Often it leads to a bit of bickering, a bit of nastiness on the topic of how that should be handled. And should it reduce the contingent percentage, and so on and so forth. And I will tell you that I hate to see it. I hate to see it because you got a firm who put up a win for someone, right? So they helped. They did the hard thing. They did the trial. They put up the victory. And then there's this uncertainty that puts the client who they helped at odds with the firm who did the helping. And man, that is not a feel-good hit. So I really would prefer to see firms specify how attorney's fees, as awarded by a court after a trial. The old phrase for this would, so now I think it's called a fee application. It used to be a lodestar application back in the day. Let's get out there and specify how this is handled in retainer agreements. What do we all think about that? Maybe we shouldn't be fighting with our clients. Maybe we shouldn't allow things like a case of the greedies to come between us and our clients. Right. Especially after we've done all the work to help them, done the hard thing, and now we're just wandering into a shit show of greed and nastiness. For what reason? Because it wasn't specified? I don't love it. I don't love it at all. So that's another context for attorney's fees. The last context for attorney's fees is come tax time. And let me stress, I am not a tax attorney. I'm not a tax professional. I do not give financial advice. If you take tax or financial advice from me, you are a bad person, a stupid person, and you probably hate yourself. Do not take tax advice from me. But often the phrase attorney's fees will come up at tax time depending on how a settlement agreement was handled. Many firms will structure the settlement such that their fee goes directly to them so that their client never pays any taxes on it. This is often described as best practices by tax professionals who help us structure these settlements. Other firms don't do that. For whatever reason, they have everything be taxable to the client and go to the client and then get their fee from the client. This is messy in so many ways and creates extra work and grief for the client, and also extra grief for the firm. Frankly, it is not a good idea. But I digress. So my understanding, which is at best a lay understanding, and you should not rely on it, is that attorney's fees in this field are not taxable even when the money goes to the client. So the client will have to, at tax time, ask for that portion of the settlement to not be taxed, because that tax should be attributed not to the client, but to the firm who received that income, right? And you can see why the original settlement should perhaps have been structured so the money goes directly to the firm and that the taxable income is never impugned to the client, right? So that is the third context where attorney's fees are often mentioned. Now, if you're in settlement and the other side's like, well, yeah, we'll pay your attorney's fees. Generally, without some contractual term otherwise, with your attorney, this might be a meaningless statement, right? If the other side, if the defendants come to you and they say, we would like to give you $300,000 and $100,000 of attorney's fees, your attorney, under most scenarios, will just hear they want to give us $400,000, of which I will get my contingency on all of it. Because your attorney is not interested what the other side wants to call, or frankly what you want to call, what your attorney achieves for you, right? So, hypothetical, we'll go with that same $300,000. The other side comes to you and says, we would like to settle with you. We'd like to give you $300,000 in settlement. If you would accept, and you say, no, I don't want to accept $300,000. I'll be paying my attorneys a contingent percentage. I need more. And the other side could then hypothetically just say, well, what if we just called all $300,000 of those dollars attorney's fees? We're just paying your attorney's fees, of which your attorney will receive nothing. And you could say, oh, well, that is a much better deal. I'll keep 100% of the money you're offering me. I accept, and my attorney will be paid $0. You see the problem. This does not work. Having the other side, or the plaintiff, or really anyone, characterize any portion of what your attorney achieves for you as attorney's fees is meaningless. If your attorney achieves a sum of money for you, generally speaking, they will be seeking their contingent percentage, so long as that is the terms you hire them under. They will be seeking their contingent percentage on 100% of what they achieve for you. Now, there's situations, firms will take a percentage of increase. Listen, negotiations happen. There are hybrid retainer agreements, there are specialized retainer agreements, there are stepped retainer agreements. Different firms have different offers of representation. So this is a generality, but generally speaking, magically deciding to say, I'll pay you $300,000 and then another $100,000 in attorney's fees, no one cares what the defendant wants to call it. There's some things that are of interest about what the defendant wants to call it. Like, well, we'll put these emotional damages on a 1099, and that might give the client some better tax options come tax time with their tax professional. That might be of interest. But calling something attorney's fees or not attorney's fees, no, not into it, not interested. And very few attorneys would hear that and say, in my opinion, in my experience as well, oh, well, the other side wants to pay you attorney's fees on top of the settlement. I'll let you keep all of that. And you might be sitting where you are right now being like, Vince sounds awful greedy right now. And maybe, but that firm you hired, this hypothetical firm, they probably spent a bunch of time and money, hundreds of attorney hours, tens of thousands of dollars, if not $100,000 on this case. And now it's settling, and the other side is trying to earmark some portion of what they achieve for you as non-contingent because they're calling it attorney's fees. And that firm took a lot of risk for you and did an awful lot to help. And you might not love it, but they're not going to say, I should let the bad guys decide what I get paid. Right? That's probably not something most plaintiff side firms are interested in this industry. Certainly, I assure you, I would not be. Oh, well, you want to characterize half the fee I achieved as attorney's fees? Well, I'll just cut my fee in half. I mean, sure, we're 80 grand in. Looks like we spent 600 attorney hours. Yeah. No, you should. You defendant, you should cut my fee in half by calling half of what we achieve for our client, half of the settlement, attorney's fees. You're right. Yeah, of course. Yeah, probably not. Not going to happen. So, not today, Satan. If that is the context in which you mean attorney's fees, where it's this idea of paying attorney's fees separate from a contingency, realistically, that can only happen when it's so ordered by a court. At least in my experience, right? Maybe there's some scenario that I'm not aware of where it could happen, or there's some retainer agreement that makes it possible, or some firm that would be so noble as to give up their fee because you want to call something attorney's fees, or the other side wants to call something attorney's fees. But I think realistically, that is very unlikely to occur. Now, I hope this answers your question. I think you have a second question about retaliation that I'm going to try to make a separate video for because I'm on 14 minutes. Anyways, like, subscribe, comment down below, share the channel so it may grow. Take care, everybody.